Hello, everyone. Welcome to Meltzer Hellrung's January webinar on the H-1B cap and lottery. A lot to cover today. Excited to be here. To those of you who have showed up on time, thank you for your punctuality. We're going to give everyone else 3 minutes to join the webinar. And when the clock runs out, we'll get started. All right. Thank you, everyone. Thank you for joining our webinar today. A couple of normal disclaimers. One, although we are lawyers, this is not legal advice. If you have specific questions for your particular company or individual employee, you must still speak to an attorney. This is just general information and an overview. Two, we love questions. If you have questions, please put them into the Q&A. We will do our best to answer questions in real time. If we don't get to your question during this webinar, we will follow up with you afterwards if you are not anonymous. Third, this webinar is recorded. So anyone who is here or not here will receive a copy of the webinar in their email and the slide deck. So please, no need to write everything down if you don't want to. You will get a copy. So let me take a minute to just introduce Meltzer Hellrung and who I am. Meltzer Hellrung, we are a business immigration firm combining an innovative service model, which is really about having a great team attorneys and paralegals with our proprietary technology, Voyager. We have over 200 clients representing companies as small as individual entrepreneurs and as large as Fortune 500 companies. In 2023, we were recognized by Crain's as one of the 100 best places to work in Chicago, and we are pleased to return to the Illinois Chamber Spotlight. Chambers is a publication that goes over prestigious law firms. We made the spotlight for Illinois in 2026, and in 2025, we were a power partner in Inc. magazine. We really pride ourselves on service. We are responsive. We want to get to all emails within one business day. We measure that in 2025. We had about 4.5-hour business response time. We were an NPS score. We measure satisfaction from foreign nationals and corporate clients on every single case. We are really delighted to have 2 years in a row with an NPS score above 90, which is just, in my opinion, a remarkable accomplishment. And we are efficient. Our technology and our systems allow us to turn around time-sensitive cases like H-1B transfers in 10 business days or less. And we really prioritize program management, which means that we are much more than someone who can prepare your cases and get them filed. That's table stakes. We are here to make sure that your program is running smoothly and you're thinking about how to attract and retain talent, how to be compliant, how to create efficient systems to grow in the future. Today, you have me and hopefully my colleague, Michael Tranzik. He's having a little bit of technical difficulty. Hopefully he'll be with us any moment. But I'm Matt Meltzer. I'm one of the co-founders and partners at Meltzer Hellrung. I work with all clients of all sizes, but I especially like to work with small and growing companies as they are building in the US and navigating the tricky place of getting early stage employees into the US market. And then my colleague, Michael Tranzik, who will hopefully be here shortly, is really one of the notable leaders in the immigration bar. He has over 30 years of experience, has worked at other firms and has worked as a policy counsel at the American Immigration Lawyers Association. And we are really lucky to have him on our team. One couple of things just to note: we offer way more than just getting your immigration visas approved. We are able to handle consular processing, global immigration, I-9 compliance, and litigation. And in this day and age when immigration is more and more complicated, we are here to service all the things that our clients need. And Voyager is the tool that allows us to do that. It's our proprietary technology that is the one source of truth for our clients and allows us to process things efficiently and creates a really strong narrative for especially employees about what is happening in their cases, so they know what is happening when, without even having to ask an attorney or a paralegal. We are putting out content every single week right now. Subscribe to our newsletter. This QR code will allow you to subscribe if you have not done so, and you will be able to get really great content in your inbox weekly that tells you all the things you need to know about immigration. All right. Agenda. Today, it's a short agenda, but lots of content. The agenda has 2 items. What is the H-1B lottery? What is happening? And 2, what's going on with the H-1B $100,000 fee rule? So we will go over both those things today. Lots to cover. Again, if you have questions, put them in the Q&A. We want to hear your questions. We will do our best to answer them in real time. I see Mike just joined. So Mike, welcome. If you want to turn off the mic and just give a second to introduce yourself, go ahead.
Thank you. I'm so happy to be here. We were having some glitches with the technology this afternoon. So thank you all for being here. Michael Tranzik, Senior Counsel. We are here to talk about 2 topics we have talked a lot about over the last few months, but there have been some significant changes since we last talked about these issues, and I'm happy to be here. Look forward to your questions.
All right. And Mike, if you're going to be on video, I'll join you as well.
Oh, hi.
Although, of course, the Zoom background doesn't want to recognize me right now. Oh, my goodness.
I am happy to be on or off. I'm just happy to be here.
We'll just go with no background.
Okay.
Okay. The H-1B cap, the lottery. This is one of those things we've done a webinar on this topic for years and years and years. It has never There have been little tweaks, little changes, digital lottery registration, getting people, getting from paper to digital, getting changes about one single registration as opposed to multiple companies. But this year we have something really substantive and new. So let's talk about what the H-1B cap is if you're new to this world. Let's talk about what is changing in 2026. So the lottery, let's just talk about what is an H-1B first before we get here. H-1Bs, for those of you who are new to this altogether, are specialty occupation visas. They're the perhaps most common employment visa for high-skilled labor. It is for positions that require a bachelor's degree or higher in a specific field or fields, and the individual you are sponsoring has a related degree. So almost anything that you can think of as a white-collar worker can qualify for an H-1B, anything from your accountant to your doctor, to your lawyer, to your software developer, to your engineer. It is not for low-skilled labor. So let's talk about where we have been. Up through 2025, the cap process included the following steps. We had an electronic registration, which was beneficiary centric. What that means is that the H-1B is cap limited. There are 85,000 new H-1Bs to be issued per year. And for most of my career, there have been some more demand than there was supply. And so to determine which people are going to be considered for those 85,000 visas, USCIS has conducted a lottery to determine which applications they will review. It used to be that everyone submitted applications and they would take the paper application and determine who they're going to review in a lottery generated afterwards. A couple of years ago, they moved to an electronic lottery, which was much more efficient. Companies said which employees they wanted or individuals they wanted to submit into the lottery. And then the USCIS conducted a digital lottery. For those who are selected, then companies have the opportunity to submit a complete petition. A complete petition is a normal H-1B, includes all the forms, a labor condition application, and then the USCIS actually reviews and approves, hopefully, your H-1B. USCIS, under the Trump administration, has said that this random selection, giving everyone basically the same chance of selection, does not serve U.S. interests. So they have gone to a system where they're saying that they are going to change this selection from something that is random, treating all individuals functionally equally, to one that weights submissions in a different way. And so it's a wage-based weighting, and we'll talk about more about that, what that means in a minute. One thing to note is that the advanced degree exception, so when I talk about 85,000, there are 85,000 total H-1Bs. That actually breaks down as 65,000 normal H-1Bs for anyone, 20,000 H-1Bs for people who have U.S. master's degrees or higher. That's not going away, that advanced degree exception. So people who have master's degrees or higher still have a higher chance of selection overall than people who don't. And by master's degree, just to clarify, U.S. master's degrees. So if you have a master's degree from the U.K. or India or Australia, it does not qualify you for this classification. So biggest change, we're talking about how this is weighted. It will change, the weighting will occur based on the wage level that the offered salary clears. It's not which wage level the employer is selecting, it is which wage level the wage that's being offered clears. So for those of you who are unfamiliar with the DOL tools here, DOL has basically survey data about different occupations and the wages offered based on geography. So an example would be an architect. An architect they have salary data for architects. That salary data varies by geographic location. So an architect in New York City gets paid differently than one in Omaha, Nebraska. Within each geography, they have 4 different wage levels that supposedly align with different levels of experience for the occupation. So saying that typically people with more experience and skills are going to be at the highest wage level, and level 1 wages are typically for introductory position in that occupation. Mike, does this I know it's not really here to critique policy, but does this policy even achieve what the government is seeking to do?
Well, I liked, when we were doing some preparation for this webinar today, I like the way you phrased it in that, it seems very much to be a solution in search of a problem in a lot of respects, in that, and we'll discuss this, I think, in a later slide, the the volume of level one caliber H-1B petitions and registrations has diminished significantly over pretty much the past decade. I think a lot of the companies that were involved in technology consulting and other consulting areas, frankly, had recognized that the organic hurdles that the agency had developed in terms of their use of the H-1B process made it more practical, more cost effective, more efficient from their perspective to actually do a lot more of the work offshore. So I'm not sure if this is actually going to accomplish everything that they're intending to do. It will potentially have impacts on business choices, salary decisions. It'll have a huge impact on the university community. We can talk about that later if time permits. But in terms of just the raw data, and we'll have a slide that looks at it. If you typically have jobs that are being paid at levels 2 and above, this really isn't a big sea change. But let's go on.
Yeah.
Yeah.
So just to tie this in a bow, the number of selection opportunities you get or number of submissions into the lottery is weighted. So for each wage level, you get the same number of submissions. So if you have a clear level one wage, you get one submission into the lottery. If you have a level 4 wage, you have 4 submissions lottery. So it really does improve your chances, the number of the based on what wage level the salary clears. So this final rule just came out. It is effective February 27th, which doesn't really matter. What it means is it's effective for the lottery registration this year. It means that employers will need to consider this when thinking about who they're submitting. Clearly, the hiring decisions about people who are at your company today, people on OPT, those decisions were typically made well before this rule came out. This may factor into how employers choose to recruit for certain roles and who to employ going forward. It also, in the past, we've always recommended that companies consider sponsoring people on H4 and TN and other statuses for the H-1B lottery. This rule may impact whether employers want to sponsor people who are in other visa statuses who don't necessarily require H-1B sponsorship, but based on their wage level, may make them think about whether or not they should sponsor in the lottery. So let's talk about what this means. And Mike, I'm gonna just zoom ahead a second to talk about what the actual odds of selection are. So
this is a great slide.
Yeah, the USCIS in its own rulemaking created an estimate of what they think the chances of selection are based on an algorithm that they created based on previous submissions and projections of who they think will be submitted into the lottery. This is not a guarantee, but it gives you a sense at least of where the USCIS thinks things are going. So if you are submitted into the lottery with a level 4 wage, they think you have a 61% chance of selection. Level 3, 45%, level 2, 30%, level 1, 15%. Now, keep in mind, in the past, it's generally been around a 30-35% chance of selection in the lottery. So for this level 4 wage, you're almost doubling your chance of selection. And for a level 1 wage, you're basically halving your chance of selection. So it really is a huge benefit to people who are going to clear higher levels of wage and a huge detriment to people who are on the lower end. So, Mike, why don't you walk us through what do you see as where this is beneficial, where this is, where it's potentially detrimental? Tell us what are you seeing here?
Well, where I think this creates some advantages as compared to, say, last year's registration period and cap filing period is if you look at your salary scales and you compare them to the OES wage levels, and it looks like your level 3, level 4 salaries, first and foremost. I think then, as you can see from some of the data that we had on the previous slide, your chances of selection are increasing significantly. If they're in the level two category, you're probably about the same, maybe a little bit better. So I think in terms of that particular, cohort of applicants, if that was where your workers fell before, you're likely to be minimally affected. Quick footnote here. I think Matt mentioned something important. This is based upon data provided by DHS. This is based upon their analytical criteria. I don't believe we should just assume the statistical accuracy of this. There are a bunch of variables that could impact some of these percentages, including what employers like the employers on this particular webinar decide to do with respect to wage adjustment. So if we're scaling more folks into levels 2, 3, and 4, that could have a detrimental effect to those who are in level 1 there, and thereby impacting these levels negatively. So I think that's sort of a high level. I think where where this is going to impact folks is really in that STEM OPT to F1 area where you're really locked in probably for the most part to a level 1 age and in level 1 wage in terms of your salary structure.
Yeah. The other thing I would just say is that in terms of the way this is going to work, employers are really going to need to think about how they're going to file their H-1B applications if they're selected in the lottery. Right now, the registration, you can sort of put off the consideration of what you're going to do. At Meltzer Hellrung, we always create a strategy at the time of registration. We do a complete assessment of the case. How are we going to file? Are we spotting any issues that we think are going to arise at the application stage? But given this, you need to identify what occupational code you're going to use and what wage level you're going to assign. Now, again, certain positions are really easy. Like the architect we mentioned, that's real simple. There is an occupational code for architect, but there's a lot of occupations out there that are not so straightforward. There's a lot of roles that do not neatly fit into one occupational category or another, and employers are going to need to choose at the registration stage which occupational category are you going to place the person into, because you're going to need to identify the wage level that's appropriate. You can't be inconsistent between the wage level listed in the lottery and the wage level listed on the LCA at the time of the actual petition filing. All right. So a couple of things that talks about how this is actually going to change. The lottery itself, the registration portal that the USCIS has will get a little bit more complicated, not terribly so. The data that was acquired before, things like name, country of citizenship, passport number, date of birth, that kind of stuff. Do you have a U.S. master's degree or higher? Yes or no? That will all still be there. We will now need to provide the SOC code, the area of intended employment, and the wage level in the lottery registration. And as Mike was just saying, that information has to be the same at the petition. You cannot go about changing the wage level or the area of employment at the lottery at the petition stage. So for employers who in the past said, well, we have some time to figure things out between a March lottery registration and a June 30th submission filing timeline, that really moves up your decision making. You have to be consistent between those two dates. So if you are saying, hey, we don't know where this employee is going to work, you're going to have to figure it out by March. You don't have the time grace anymore to wait until June to figure that out. And if you're not sure what someone's career arc looks like, you're saying, hey, this person may or may not get promoted, we want to hold off on figuring that out until May or June. That's no longer a possibility. You're gonna have to make a decision one or the other. Now you can always pay higher wages later, but you don't have the grace of saying we want to submit at a higher wage and then paying a lower one if someone is on the precipice of getting promoted or not. Mike, anything you want to add there?
No, I mean, I think I was actually just looking at some of the questions, but I think what we really want to do sort of strategically here is work with our clients and employers to find out what is practical within the context of their business operations in terms of how we address particularly the level 1 wage issue and what options may exist to legitimately improve a particular employee's chances of selection.
Yeah. So let's talk about the timeline on all this stuff. Lottery itself occurs mid-March. The dates are not yet finalized and set, but based on previous years' lotteries, we would expect the timeline to be somewhere around like the second week of March through the third week of March. So somewhere around like March 6th to March 23rd. We are opening cases now. We encourage employers to start working on this early right now. We want to be working with clients to think about how you're going to treat each employee. But especially if you have multiple employees who are in the same role, we want to create strategies for consistency. We are concerned about how inconsistencies might trickle to other investigations with USCIS or DOL. We'll talk more about that in a moment. But creating a strategy that is comprehensive for the entire employee workforce has never been more critical. This is no longer just an employee by employee issue. As we get more data into digital systems, strategies for consistency across the workforce become paramount. Lottery selection will typically come in the last week of March, and then employers will have from April 1st to June 30th to submit actual petitions. If there is not sufficient petitions submitted through June 30th, USCIS has the ability to conduct a second lottery. There was no second lottery in 2025. There was a second lottery in 2024. So, we would not, but we'll assume that the USCIS is still perfecting their algorithm. There probably won't be a second lottery this year. One big hiccup that could occur here is potential litigation. There has not yet a lawsuit. The rule just came out very, very recently. This rule could be challenged. There are some very good grounds to potentially challenge the rule. Just a question of who is willing to, and actually going to do so. But if it's challenged, this whole thing could get paused. And if that happens, the lottery would probably just occur as it has in the past with a beneficiary-centric system and no waiting. But we will, at Meltzer Hellrung, we're going to continue to operate assuming that the lottery will work this way until there's a reason to think it won't.
Right. And I would just say, I mean, and I think we've mentioned this in prior webinars, but one of the legal challenges will be statutory, in that the actual language of the H-1B statute requires a random selection process. And the question really is a process in which the government puts its proverbial thumb on the scale and creates preferences for certain applicants over others, is truly a randomized selection process. In fact, when the government did a prior effort to create a salary-based selection system, they said in their commentary, almost verbatim, that to do a weighted selection system would require statutory change. So they've actually opened up the door in a couple of avenues to potential litigation. And then, so the question really does become sort of litigation timing. When is the lawsuit filed? When is there a hearing on the preliminary injunction? And can this happen before early March, when we anticipate that the registration process will open?
Yeah. One thing is a really good question here that I think it's really important to clarify. One person asked, can we have different wage level in the registration and the actual LCA filing? And I think that's really important to clarify. So in the lottery registration, the level that's listed is just what is the highest level that your salary clears. So if the wage level, the highest wage levels, level 4 wage for your occupation is 91,000 and you're paid 100,000, you clear the level 4 wage. The registration should reflect a level 4 wage. If your employer says this is a role that typically only requires 2 years of experience, your employer might file the LCA at a level 1 or level 2 wage level, is saying that's what the prevailing wage is. Your offered wage is going to say the same. So there very well may be a mismatch between the lottery registration and the level listed in the LCA. I think that it's the level going down from the registration to the LCA is the only possibility. There should not be any real reason why the level would go up.
Yeah.
Um, so I think that, with this, Mike, so much of this rule um, becomes what happens afterward. Like, what happens when something needs to be a change subsequently? And I think this is, the reality is, like, when the government creates rules, people are going to try to game the rule. And the reality is that because the wages are location based, the same salary will create different wage levels in different locations. Someone who is getting paid $100,000 in Palo Alto may be a level one wage, and that $100,000 wage may be a level four wage in Bozeman, Montana. So if your employer, if you are people very well might be thinking, should I be moving to Bozeman? Does it give me, because it gives me a higher chance of selection in the lottery? Now, if the company has multiple offices, that's pretty logical to move from one place to the other. If it is just about remote work, it creates a whole another host of issues. Um, the strategy about what to do, when can you amend, when can things change, uh, that's a really live question. The USCIS has said that they are going to be looking for change, that they're going to be trying to seek out fraud. They're going to be trying to figure out, was someone trying to take advantage of the system? Because this is brand new, your guess is as good as mine about what to do. But let's just think of this, Mike. If an employer comes, if a company were coming to you and saying, "Hey, we have two offices, one in Bozeman and one in Santa Clara, and we want to put someone in the Bozeman office to get the higher wage level in the lottery," what are you advising about, like, how someone should, considering having someone move to Santa Clara sometime afterwards and filing an amendment?
Well, as you said, yeah, no, that is one of the really key questions here that really hasn't been answered with any specificity yet. In the extensive final rule, they really have highlighted the fact that they are going to be extremely conscious about efforts to um, change salaries, change work locations in a way that creates advantages for some workers over others in this rule. So my own perspective, and I think that it was actually referenced at one point in the final rule, is that they're going to be looking very hard at the facts and the circumstances around any subsequent relocation. So, you take the extreme and ridiculous example where they're in Bozeman, Montana, in your hypothetical, and they're there for 30 days and then they move to Santa Clara, where they would have only had one entry, where they might have had two or three or four even in Bozeman. I think that's one of those cases that's going to be a red flag for the agency in terms of an amended petition filing to note the new location. So I think now that could still be legitimate. Now I don't want to say that that's per se illegal. It could be appropriate, but again, it's going to be the facts and the circumstances that are going to drive a lot of this analysis. And I think if they start to see, I would just again, I'm talking from my perspective as a lawyer who's worked in this area for a while. They start to see patterns and practices of certain employers doing certain things where they're moving H-1B workers from higher registration locations to lower registration locations. I think those are areas where fraud detection agency, part of USCIS, is going to have a lot of activity.
Yeah, I think this is something where we are going to be not knowing the answer on this question for a year or two, until facts occur, that we start seeing where are our fees, where are notice of intent to deny occurring as people seek to change locations. But I do think, what we are saying, at least at Meltzer Hellrung, is that if employees are changing locations, you really need to keep the wage level consistent. If you are a level two, if you said you're going to pay a level two wage in Bozeman, again, not what did you register in the lottery at, but what was the LCA filed at. So if you took advantage of the location to clear a level four wage in the lottery, the LCA could still be a level two wage, as saying that that is the prevailing wage, not the offered wage. The offered wage is going to stay the same. The prevailing wage is what was in the level two, because that's the appropriate classification for the position. When you move to another position, you need to, not the location, keep the same wage level of the occupation if the position is the same. So there is some strategy there also to consider from an employer perspective about what wage level is being chosen in the LCA
Yep.
regardless of what was in the lottery submission, to make it feasible for employees to move from one location to another.
Yep.
And in the era of remote work, it's been a live question that we've been thinking about in H-1Bs, just as a full issue to consider any time, but it becomes even more important in this lottery.
Yeah, and just to put a point on what you said, Matt, I think if you do move from Bozeman to Santa Clara and you stay at the level two wage for the LCA purposes, you need to do the analysis of what the required wage is, and you sort of touched upon that in your comments. It's looking at what the prevailing wage is in Santa Clara for this level two job, and that may require an adjustment. You may have to increase the wage to meet the level two salary. So
Yeah. Um, so
if I could just actually, I want to
yeah,
make
go ahead.
one other point in terms of that slide, which was really the things that were unknown here is really how is this new lottery system going to affect the calculus that employers are engaging in right now in terms of whether they sponsor individuals for the H-1B. I think we really recommend that you do that statistical dive, look at what your past practice have been. That's concrete. You can analyze what your H-1B sponsorship was last year and where they would fit if they applied this year. You can also look at your existing OPT workforce and others you might be initially considering for H-1Bs, say L1s, et cetera, and look at where they would be in the system and determine, right, well, are we comfortable with them at level one or level two, or would a raise of $2,000 kick them into another level where they get another registration? Those are business decisions I think that a lot of employers have to look at. We also need to think about given the confluence of events around the H-1B visa and the fact that you've got major employers like Cognizant, TCS, Deloitte announcing that they're going to be decreasing usage, does that necessarily mean that those who do file registrations right now have a significantly better chance of success? I mean,
Yeah.
it's unclear. It's unclear. I have to say it's unclear, but it's a possibility. Yeah.
My from what we are hearing just from our own clients and from what we are hearing industry wide from talking with other attorneys and what we hear about through the grapevine, we think there's going to be a lot lower number of submissions this year than in 2025, potentially quite significantly, like at least 10 or 20% lower. So you sort of take these numbers that the government is putting out there about chance of selection, you probably pump them up a little. That means that the level four wage might not be 65%, it might be 75%. The level one wage probably isn't 15%, maybe it's 20 or 25%.
Yeah, that was exactly my point. So thank you. So yeah.
Yeah. So given the uncertainty around other things happening in H-1B, given that there's potential changes to the H-1B wage structure altogether, given that there is, uncertainty about where the $100,000 fee rule, which we'll address in a moment, is going. I've been encouraging my clients to be aggressive in this lottery. That I think this is potentially the best chance of selection in a knowable regulatory environment that we will have potentially in the entire Trump administration. Like if other employers are running scared, this is the opportunity to be aggressive and put people through. We might not have the same advice in 2027. So 2026 may be the best year. So my advice is not to shy away from it, but to run towards the uncertainty.
Yeah, and I think we've done some scenario discussions in prior webinars about what might happen if litigation ensues, which is, we can get, there are jurisdictions that might be favorable, court jurisdictions that might be favorable to issuing an injunction here and staying this, which again, as Matt said, would refer to the existing registration system. And certainly the government has anticipated that, and they would probably file motions to enjoin the injunction, if you will. So we'll have to see how some of this timing plays out. But I think just because the timing is so tight, right? The timing is so tight right now that it's certainly a possibility that this could get kicked off into next year. And my point specifically is, and this is really just amplifying Matt's point, which is this year could be, I think, the last year under the known system that we've worked with over the past years. My own personal opinion, not the firm's position, is that it is very likely at some point that the administration will be successful in changing the registration process. I think there are strong legal arguments that they have authority to do so. They may just not have done it the right way this time. So I think that's something to keep in the back of your mind as you're doing your analysis for the upcoming cap season.
All right, Mike, take it away. Talk about what's happening with the $100,000 fee rule.
Yes. I'm not going to spend a lot of time talking about what it is because I think we've all had a couple of webinars since this appeared on the horizon a few months ago. But what I am going to tell you is just sort of an outline of where we are since I think the last time we discussed this in any depth. This slide is really just to give you an overview of the H-1B program, which Matt has done a good job of earlier on, but really to highlight where this $100,000 fee payment sort of fits into the process flow of the H-1B program. The way it has been structured is that the H-1B $100,000 fee is part of the filing of the H-1B petition. The USCIS DHS rules have required that $100,000 fee be paid through the paid.gov website, and that proof of payment must accompany the petition. So far, there's not been a lot of evidence that petitions have been denied or rejected based upon this fee, but we have heard of RFEs. There have been several RFEs issued to employers requesting them to provide the fee. Now, once the petition is approved, then the individual is going to have to go, is typically going to go abroad if they're subject to the fee, right? And apply for the visa, at which point DOS will do their own independent verification. So that's how the process is designed to work right now.
Mike, if someone is in, just to clarify, if someone's in the U.S. today, let's say they're on OPT, they're on TN,
Mhm.
if you don't submit the $100,000 fee rule because you say I have no intention of leaving the U.S., can you do that?
Yes. Yeah. I mean, the short answer is when the initial proclamation was announced, it was so broad, so amorphous that there were lots of categories that were of prospective H-1Bs that were included when that White House Oval Office announcement was made that were pretty clearly illegal, right? In terms of trying to structure this as a travel ban, including individuals who are in the United States and applying for change of status. As a result, the agency in their efforts to really try to sculpt this proclamation down to something that was arguably legal, they explicitly stated that if you are applying for a change of status and the change of status is approved, then you are not subject to the $100,000 fee. Caveat, if it is not approved, then you would have to pay the $100,000 fee before the underlying H-1B petition could be approved because the presumption is that at that point you're going to go abroad and get the visa stamp, which would trigger the fee. So that was one big carve out from the time that announcement made until the effective date this requirement was implemented. So if we go to the next slide, and again, this is
Yeah.
another slide that I'm not going to spend a ton of time on, but I do want to emphasize that this proclamation is time limited. It will exist for this cap season and beyond. If you're a cap exempt employer, then it's already impacted you potentially and will impact you throughout the year. But the primary focus was to have this in effect for this upcoming cap season. So, what other points do I want to make here? A couple. There is a waiver process. I've heard from colleagues in the immigration bar of several applications for waiver of the fee having been submitted with extensive documents of the national interest of their particular petition. To date, no one has received anything other than a receipt acknowledging the waiver request. So these applications are still pending adjudication at USCIS. I would note that Joe Edlow, who is the head of USCIS, has on more than one occasion indicated that these waivers are very likely to be narrowly administered. So I think it's something that we need to keep that option available to us. We need to consider about what our national interest arguments might be for a waiver of this fee, but understand that it's probably less likely than more likely. Not unworthy of pursuing, but less likely than more likely. The other point I'd make here is that whether or not this $100,000 fee survives legal challenges, which we'll get to in a couple of minutes, um, there are other regulatory changes in the pipeline that could impact the H-1B program. One is very likely to be published in the very near future, which is a Department of Labor rule restructuring those four wage levels that we've been talking about a lot today, with the effect of increasing the floors, if you will, of each individual level, so that, for example, the current level one, which I think is around 17% of, if you think of the median wage for an occupation across an area of intended employment, going from 17% on that scale to 34 or more percent. So, more than doubling. So a significant increase in salaries in these four wage levels will be will be the net effect of some of these changes. There are also a pending rule that isn't nearly as close to publication that would change some of the eligibility criteria for the H-1B category with a view to this consistent messaging from this administration that the H-1B visa is really intended for high skilled, high level occupations, the proverbial best and brightest. But yeah, let's talk about the litigation right now because I think that's the hot topic for everyone. So again, just to summarize, here's the litigation that has been adjudicated and has been in the news in the last week or two. This is the U.S. Chamber of Commerce litigation, joined subsequently by the Association of American Universities. Their claims essentially were twofold. That one, that this presidential proclamation was beyond the scope of the president's authority under this travel ban, that it's not really a travel ban, that it really is an illegal fee imposed without following proper procedure. And then, again, there's an Administrative Procedure Act argument that, in doing this, there was no notice and comment period. There was no proper process attached to it. So those were the core arguments: illegal fee, improper procedure. Motions were filed. The court procedure was moved on a relatively quick basis. There was a hearing on December 19th, just before the holidays, and then a decision on December 23rd by a district court judge in the District of Columbia. And we go to the next slide that sort of provides a quick one-page summary of the decision. So I don't know if I can move the slide. Let me see. There we go. So bottom line, the judge endorsed and accepted the government's argument in total, and pretty much in total. There's a reason I guess they call them legal opinions, because it was a very opinionated analysis of the two parties' case favoring the government. In essence, with respect to the first issue, the judge accepted the government's argument that this is in fact a travel ban, not an illegal fee. And because it is a travel ban, and that particular section of the Immigration and Nationality Act, 212F for any of you legal lawyers in the audience, provides the president with really broad discretion to create restrictions upon entry to the United States. So she accepted that this fell within that particular provision of the law. And then in a more nuanced analysis, she took the APA argument and said, well, even if you're right, really, because the agency was just implementing a presidential directive, they had no discretion. And because they had no discretion, any defect is harmless error. So she dismissed it in what I thought was, I certainly did not anticipate that kind of analysis. And just essentially just a sort of broad brush rejection of the plaintiff's argument. So
This is getting very nerdy about for people
yeah,
who, if
yeah,
anyone out there say likes talking about administrative law, this is like really deep in the weeds of administrative law. But the most important thing is, even in that decision, Mike, the judge acknowledged that there is not consensus in the DC district. And so this is on this specific issue. And so she took her best swing at it where she thinks how the cookie crumbles. But this case has already been scheduled for appeal to the DC Circuit Court. So that's
Yeah,
the court between the district court and the Supreme Court. That's a three-judge panel who will decide the case, and they'll review this district judge's opinion, and they may agree or disagree.
yeah,
But I think that one you mentioned about, does the did the what there did there have to be rulemaking on this to implement it? I think that's a really live issue that even the judge acknowledged is not fully decided under case law. So
yeah.
that's probably my guess. That's going to be a really one of the biggest issues that comes up in the appeal.
Yeah. Yes. And I will also just mention, having had conversations with colleagues I know at the U.S. Chamber, they recognize that the D.C. Circuit may not have been the ideal venue for this in terms of their perspective on immigration law and immigration litigation in general, but it's the U.S. Chamber. They're headquartered a couple of blocks from the White House. They were really kind of constrained in terms of the jurisdictional options they had for bringing the suit. Unlike the other two lawsuits, then maybe I know we're getting a little close on time and there are a bunch of questions, so maybe we can just jump to I think probably the last slide at this point and just talk about where we are with the lawsuits. Um, so as you said, Matt, the U.S. Chamber has already filed its notice of appeal with the Circuit Court for the District of Columbia. They've just announced that the court has ordered an expedited briefing schedule. So the chamber's brief is due on Friday. The government's due before the end of the month. I think with a view to having an answer on this issue as soon as possible, and certainly in advance of decisions being made about whether to sponsor individuals for H-1Bs in the registration process. So they realize that there is some time urgency to getting this resolved, in February. Similarly, the other major litigation, generally referred to as the global nurse litigation, because that's the lead plaintiff, which is happening in the Northern District of California. They also have an injunction hearing pending for December. So I think December is going to be a really critical month here in terms of deciding the outcome of the $100,000 fee. There was also a lawsuit that was filed just before the holiday by a collection of approximately 20 states that they're arguing a lot of the similar grounds, but that was filed in the district court in Massachusetts. So arguably a couple of jurisdictions that might be more amenable to petitioners' arguments here. Also, lastly, and again, this is really geeky stuff. I understand that the 20 states had joined and filed an amicus brief in support of the global nurse case. So they're all sort of connected, sort of through dotted lines. So there are no shortage of good lawyers working on plaintiffs' arguments on this as we speak.
Thanks, Mike. Um, I think that with this mind, that what we're going to see is that I think it's very likely that the DC Circuit Court comes out with a decision one way or the other before the lottery is conducted. Uh, whether these other two cases, the Massachusetts case and the California case, get a decision before then, hard to know. But there's, with anything that you're dealing with multiple judges in different circuits, and we're talking about administrative law, which is, we're really deep in the weeds here. And what's important to know is that the Supreme Court creates consistent law across the country. If the Supreme Court hasn't decided an issue, circuit courts each have their own law on the issue until the Supreme Court decides an issue. So there are thousands of issues where there can be differences between different circuit courts. So we talk about what's happening in DC, but there's different law potentially in California, which is the Ninth Circuit, and Massachusetts, which is the First Circuit. And so there very well could be different outcomes in these different cases. And if that's the case, we are going to have to wait until the Supreme Court probably harmonizes a rule one way or the other. They're going to have to make a decision.
And yeah, and actually that's a good point, because one other area where there could be differences of approach is with respect to the scope of relief that might be granted. And I think there's a strong desire to have sort of a nationwide injunction on this rule, but that may not necessarily be where the judges land. So we'll have to keep an eye on that one very closely.
Uh, that is all the question. That's all the topics for today. I will just conclude by saying that there's a lot of moving parts here. Uh, for me personally, for submitting employees into the lottery, especially if the employees are in the U.S. today, uh, my personal guidance is to move forward and do so. If you have employees that you're thinking about sponsoring who are currently abroad, the people who you would consider moving from foreign offices or people you would like to recruit and bring into the U.S., you know, just a bit of a wait and see approach on what happens with the $100,000 fee rule, because those people would certainly be subject to the $100,000 fee rule if they're not in the U.S. and you need to file for them. If there is, it's struck down before the lottery, great. If it is inconsistent or there's unknowns at the time of the lottery, I would recommend filing in the lottery, because there's a limited cost and exposure in filing in the lottery. And if you have a selection and things go the right way, you want to submit in a full petition by June. And so you buy in there 3 months for yourself. I think that it's very likely we will have final decisions on everything by June 30th that allow employers to make just know for a fact whether or not they're going to have to pay $100,000 for each of these applications.
Right. And I just add, I mean, and we've talked about this, and I think there's the added sort of HR factor, a decision not to sponsor someone in the registration process for this year who is F1 OPT or someone else who has very time limited work authorization. It's going to send a clear message to them about their future with your company. So I think that, keeping in mind the amount of investment that you all make in your F1 OPT students, and the thousands of dollars of training and work that go into getting them to the point where you want to sponsor them for an H-1B, not putting them in the registration process probably shortens their tenure significantly. So,
well, thank you, Mike. Thank you as always, for sharing your insights. To those of you who are already Meltzer Hellrung clients, thank you for your time and your support. We are grateful to continue to work with you. For those of you who are not yet Meltzer Hellrung clients, we would love to talk to you if you are interested in hearing more about what it's like to work with Meltzer Hellrung. There's much more to come. We will continue to update everyone through our newsletters and our blogs, LinkedIn. There's a lot of ways to follow our content. There certainly will be a webinar in February. If things change, we will keep you all updated there too. Thank you for your time. If we didn't get to your questions in the Q&A and you are not anonymous, we will follow up with you in the next day or so. So thank you very much for all of your questions and your time, and we look forward to speaking with you soon.
yeah, thanks again, everybody. Nice talking to you. Take care.